one of the most protective doctrines in use of force law. Agent Ross has absolute immunity, right? Completely wrong. Legal kidnapping. Person with a gun. Good as a bitch. Justified or the officer's immune are so corrosive. Courts are no longer permitted to isolate the final second of fear and ignore the chain of decisions that led there. Good afternoon, everyone. I'm Stephen Teske, and welcome back to the Teske Brief. In earlier episodes, we addressed immunity, myths, civil versus criminal accountability, and how federal officers may attempt to remove state criminal prosecutions to federal court. Today, we're going to focus on why that removal fight just got much harder. Episode 4, this episode, is titled Officer Created Danger, Escalation, and Why the Final Second Isn't the Whole Case. You see, because in 2025, just this last year, the United States Supreme Court rejected one of the most protective doctrines in use of force law. The old rule, what I call the snapshot rule, for years, courts often evaluated police shootings by looking almost exclusively at the final moment, the instant when the trigger was pulled. Now, if an officer could show they were in danger in that moment, that inquiry often ended. That was it. Everything that happened before faded into the background. It was like totally irrelevant. That approach was known, formally or informally, as the moment of threat doctrine. The new rule, the moving picture here, well, in Barnes versus Felix, that's that 2025 case I just mentioned, the Supreme Court rejected that approach. Now, I mentioned in the last episode that as I've been doing research, taking a look at what other persons are saying who are like myself, a lawyer or seasoned law enforcement, and talking about the shooting of Miss Good, many of them, unfortunately, were making analyses based upon the old snapshot rule. I don't think they even knew that the 2025 Barnes versus Felix case was decided that rejected the snapshot rule because no one mentioned anything in these analyses that they provided that led up to the shooting. They just emphasized that moment when right before Officer Ross pulled the trigger. Now, the court in Barnes held that judges and juries must evaluate officer shootings based on the totality of the circumstances, that is, including the officer's own conduct leading up to the use of force. In plain English, ladies and gentlemen, courts may no longer put blinders on. They must examine how the encounter unfolded, how it escalated, and whether the danger the officer perceived was created or intensified by the officer's own actions. So why does this matter for the issue of criminal removal to federal court? Well, you see, this ruling fundamentally alters the removal analysis that we discussed in episode 3. You remember the Supremacy Clause test? Was the officer authorized by federal law? And did the officer do more than what was necessary and proper? You see, under Barnes, necessary and proper now includes pre-seizure conduct. What happened before the decision was made to pull the trigger? If an officer's reckless or unreasonable actions escalated the situation, that conduct is part of the constitutional analysis. That matters not only at trial, but at the removal hearing itself to decide if there's even going to be a trial, whether it's going to remain in state court or in federal court. So let's talk about this officer-created danger. What do I mean by that? So officer-created danger occurs when law enforcement actions unreasonably place officers or civilians in harm's way, and lethal force is then used to resolve a danger the officer helped to create. Let me give you an example here, or multiple examples. Unnecessary positioning in front of vehicles, rapid or conflicting commands, failure to disengage when disengagement was possible, ignoring training designed to de-escalate volatile encounters. You see, under Barnes, courts are no longer permitted to ignore these factors. To understand why Barnes versus Felix matters so much here, we need to slow down, talk briefly about what that case was actually about. So, real quick, the facts in Barnes is like this. An officer named Felix stopped the vehicle for toll violations. The driver, Barnes, told the officer he did not have his license on him and that the car was a rental in his girlfriend's name. Barnes said that he might have identification in the trunk, and the officer instructed him to open it from inside the car. Well, then everything changed. As the officer stood next to the vehicle with his gun unholstered, Barnes turned the ignition and began to move forward. Rather than step back or disengage, the officer jumped onto the door sill of the moving car. His head was above the roof line, meaning that, he could not see into the vehicle. From that position, the officer fired 2 shots into the car. Barnes was struck and later died. The estate of Barnes sued under Section 1983, alleging excessive force in violation of the Fourth Amendment. So that's a civil case, as I had described before in Civil versus Criminal in the last episode. Section 1983 would apply because this was a local or state law enforcement, where it would not apply in this case involving Good because this is a federal officer. It would have to be under a Bivens action. But as we learn about Bivens, the Supreme Court has been very wary about applying that to ICE agents because they are the ones who secure our borders, and it involves sensitive things like the potential of international and national domestic security. Now, the lower courts never reached the full question, okay? Why? Because they applied what became known as the moment of threat rule. So think about it. The district court decided in favor of Felix, okay, all right, because they said they only looked at the 2 seconds before he fired the gun, thinking only that he was on the door sill of the car, no explanation why he was on the door sill of the car. But the problem is because the lower courts have never considered the factors leading up to that, okay? They did so because they've always applied the moment of threat rule. They focus exclusively on the last 2 seconds, the moment when the officer stood on a door sill, as I said, and perceived danger. And looking only at that snapshot, the courts concluded the officer could reasonably fear serious harm, and the case was therefore dismissed. And the Supreme Court unanimously rejected that approach. And here's what the court said, I'm quoting. Under the so-called moment of threat rule, a court looks only to the circumstances existing at the precise time an officer perceived the threat inducing him to shoot. Today, we reject that approach as improperly narrowing the requisite Fourth Amendment analysis. To assess whether an officer acted reasonably in using force, a court must consider all the relevant circumstances, including the facts and events leading up to the climactic moment, that is, the shooting of the gun. Now, that sentence matters. For the first time, the court made clear that juries and judges may consider whether an officer's own decisions contributed to the danger that later justified. Applying this to Minneapolis, let's look at this, okay, with what happened with Renee Good. Video evidence matters here, not in isolation, but in sequence. I showed an excerpt of the New York Times synchronized videos in episode 2. But this excerpt that I showed you in episode 2 was just before, during, and the moments after the shooting. But let's take a look at the video in its entirety to see what happened before this supposed moment of threat. Because now, after the Barnes decision, the events leading up to the decision now can be.
Here's how events unfolded. Moments before the shooting, the victim's maroon SUV is stopped in the middle of the street. Multiple unmarked federal vehicles are idling nearby. Secretary Noem alleged the motorist, quote, was blocking the officers in. Bystanders are blowing whistles and yelling at federal agents.
Go home to Texas!
Then, federal vehicles start moving toward the maroon SUV, with sirens and lights blaring. A federal agent films the scene on his phone. The driver rolls forward slightly, turning left, then stops and waves for others to go ahead. Two agents exit this silver pickup and walk toward the vehicle. Moments later, shots are fired. Let's look at the scene again more closely. This is the agent who shoots the driver. He walks around the car filming and disappears from view. Other agents pull up and order the driver to exit her vehicle. One of them grabs at the door handle and reaches inside. The SUV reverses, then turns right, apparently attempting to leave. At the same time, the agent filming crosses toward the left of the vehicle and grabs his gun. He opens fire on the motorist and continues shooting as she drives past. The moment the agent fires, he is standing here, to the left of the SUV, and the wheels are pointing to the right, away from the agent. This appears to conflict with allegations that the SUV was ramming or about to ram the officer. President Trump and others said the federal agent was hit by the SUV, often pointing to another video filmed from a different angle. And it's true that at this moment in this grainy, low-resolution footage, it does look like the agent is being struck by the SUV. But when we synchronize it with the first clip, we can see the agent is not being run over. In fact, his feet are positioned away from the SUV. The SUV crashes into a white car parked down the road. A bystander runs toward the collision. The federal agents on scene do not appear to rush to provide emergency medical care. Eventually, the agent who shot the motorist approaches the vehicle. Seconds later, he turns back around and tells his colleagues to call 911.
Shame! You shot someone! You shot someone!
Agents block several bystanders who attempt to provide medical care, including one who identifies himself as a physician.
I go check a pulse!
No! Back up! Now!
I'm a physician!
I don't care!
Understand.
At the same time, several agents, including the agent who opened fire, get in their vehicles and drive off, apparently altering the active crime scene.
Okay. Now that you've seen that, okay, I'm going to go a little bit CSI on you. The crime scene investigation television shows that have popularized the use of advanced forensic science to solve crimes. A little side, and the truth be told, now, first of all, let me just say this. The reason I'm going into it is because there is some technology that most likely will be used if this were to go on to a removal hearing, whether a criminal prosecution But even in a civil case, if one makes it there, okay, available and can be used. In this particular case, if it goes that far, and that has been applied to the shooting in Minneapolis, okay, it specifies allow the forensic expert to describe this technology while walking us through its application at the moment of the shooting. So watch and listen to this expert walk us through the forensic videoing sequences of the shooting of Miss Good.
Using the same video forensic tools as agencies like the FBI, this nonprofit group is giving us a unique look at Renee Good's fatal shooting.
We're based in Paris, France, and we specialize in visual forensics.
Francesco Sebregandi says he and his colleagues at Index are able to combine videos and create animations based on frame matching between multiple videos and photogrammetry, which Index says provides highly accurate measurements of time and distance that allows them to create animations.
And so, for example, we can place in the 3D model the vehicle exactly in the position as we see them in the images, but then are able to look at the scene from another angle because we have a 3D model of the scene.
The videos show angles from behind Good's car, from above, and from the video recording by the phone of the agent who fired the shots. Here is what Index concluded. The study is inconclusive as to whether Good's car actually did or did not make contact with the ICE agent in front of it. The Index study says it is clear that the agent was seen alongside the car as it turns to the right and is no longer a threat of running him down. And at this point, he fires a second shot at Good through the driver's side window, and then a third.
He was not in immediate physical danger, as in particular with regards to the second and third shot, as I think it can be seen when we freeze the video itself, but also more clearly once we change angle within a 3D model.
With Good mortally wounded, the car goes out of control down the street and crashes. DHS's use of force policy says that an agent should avoid placing himself in front of a vehicle that could be a threat and advises against shooting at moving vehicles.
Okay, so you've seen that. So this type of technology, as you can see, is available. And if this went to a removal hearing and onto a trial, it would likely be used. I thought I would highlight this to give you an idea of what is out there to help the judge and jury make decisions. Okay, now that we have an understanding of what took place before the shooting as well as during the shooting, we can likely agree on the following. Okay, Renee Good reverses her car. Renee turns her wheels away from the officer to the right. The officer's legs are out of the vehicle's path. Shots are fired from alongside the vehicle, not from directly in front. And the time the agent took to walk around Miss Good's car, recording her on his phone, and coming face to face with her and never engaging her to either move the car or get out of the car, both of which maybe would have likely prevented a shooting, possibly. A jury could consider that. But despite what we saw, I need to caution everyone here. This episode, this series is not about judging the ICE agent and coming to a conclusion. This series is about bringing you what we do know and what the law says, and to dismiss the myths out there, like, for example, Vice President Vance saying that Agent Ross has absolute immunity, right? Completely wrong. Okay, but despite what we saw, keep this in mind, that these facts alone do not resolve the case. In other words, what we see in the video. I'm not, like I said, I'm not presenting this for the purpose of having anyone draw a conclusion as to guilt, because such conclusions should come after a full-blown independent investigation. And by the way, best that the investigation is done not by the agency that employs the ICE agent who shot Miss Good, but also, all the evidence that is presented to a jury, along with all other evidence and testimony that has been deemed competent and evidence worthy to scrutinize and deliberate with guidance from the judge, who must instruct the jurors as to the obligations and rules for scrutinizing and weighing evidence, as well as helping them understand the standard of proof, which is beyond a reasonable doubt, and how to apply that to what they find the facts to be most truthful. Okay? Now, all evidence, not just this video evidence, under the Constitution must be weighed. So please be careful. Only by a jury can a conclusion be reached, not us. So please do not misunderstand. What's being presented here is to draw a conclusion, but to help you kind of figure out what we do have before a trial on the removal, whether or not a case should be removed to federal court or not. Now, let's take the perspective of the state's attorney for a moment. Let's say we're in a removal hearing, and the state prosecutor doesn't want it removed to federal court. All right? The state's position is this. So imagine you're a local prosecutor, a district attorney. You have a dead citizen, a grieving family, and evidence that a shooting was unjustified. You believe in home rule, the idea that your community should decide what happens on its streets. From the state's perspective, federal removal feels like a legal kidnapping. The feds are reaching down into a local tragedy and moving it behind the closed doors of a federal building. It might not literally close doors, but that's how it feels to a prosecutor, often before a jury ever gets to hear the facts. The state's counter argument is simple. No one is above the law, not even someone with a federal badge. And the prosecutor's playbook is to destroy the supremacy immunity by showing that the ICE agent acted outside his scope. It goes like this. Number one, the logic. Immunity only exists if the act was authorized by federal law. Okay. Number two, the prosecutor is going to attack it this way. If the agent was violating agency policy, acting out of personal malice or pursuing a personal vendetta, they are no longer the United States. They are just a person with a gun. Examples, for example, all right? Frolic and detour. Let's say an ICE agent stops at a bar, gets into a fight, uses his or her service weapon. They can't claim Supremacy Clause protection because their federal duty ended when they walked into the bar. The malice or excessive force argument. This is the most common counterattack in police shooting cases. The prosecutor will concede the agent was on duty, right? I'm not going to argue that, okay? But that the force used was so egregious that no reasonable officer could have thought it was necessary. And then, like we talked about in the last episode, the Nagel standard, the Nagel precedent requires the agent's belief to be honest and reasonable. And the prosecutor will take another attack by presenting evidence, body cam footage, witness testimony, or forensics to show the agent acted with criminal intent or wanton disregard. The goal of the prosecutor? You see, if the prosecutor can prove the agent acted out of malice, a desire to cause harm, rather than a desire to enforce the law, the immunity vanishes. And by the way, even though you didn't see it in that particular video, there is a video out there that captures this officer immediately after the shooting, and the car is going off. As you saw in the last video, the officer who did the shooting did call out, in reference to Miss Good, as a bitch. Now, I don't know if that would end up being admitted because it was after the shooting, or if the prosecutor could be successful in arguing that, no, it's not prejudicial, it goes to his state of mind, okay, towards Miss Good. So, the standard of proof hurdle. Let's talk about that. And in these removal hearings, the prosecutor will argue that the judge shouldn't dismiss the case unless it is a crystal clear that the agent is immune. So even if the case ends up getting removed to federal court, the prosecutor still wants to make sure it doesn't get dismissed altogether there. Okay? He wants to make sure that he puts enough doubt in the mind of the judge that this is a matter that the judge can't decide. There has to be evidence presented. A trial must occur for a jury to make the decision. Now, they will argue that if there's any conflicting evidence about that, about what happened, like what I said, okay, let's say, let me give examples now. A witness says the victim's hands were up, but the agent says they weren't. That dispute must be decided by a jury, not by a judge in a pretrial hearing, like a removal hearing or some other motion to dismiss, or in a civil case, a motion for summary judgment, okay, or not a judge at a preliminary hearing, okay? So let's talk about something that's going on as I come to a close here. The early declarations made by the administration, I mean, just minutes after this happened, Homeland Security Secretary Ms. Nome, even Vice President Vance, in saying that Agent Ross had absolute immunity. Even the president himself. Early declarations are very dangerous. This is why premature statements that the shooting was justified or the officer is immune are so corrosive. They attempt to freeze the analysis at the final second, precisely what the Supreme Court has now forbidden. Accountability does not assume guilt, but it does require context, ladies and gentlemen. Okay? See, for a federal officer seeking to remove state murder charge, Barnes versus Phoenix changes the whole terrain. The state prosecutor can now argue, even if the officer perceived danger at the final moment, the danger was created by, let's say, unreasonable pre-seizure conduct, and therefore the act was not necessary and property. That argument goes directly to immunity, and if immunity fails, removal fails. Now, what Barnes versus Felix ultimately teaches us is this. The Constitution does not operate in a freeze frame. Courts are no longer permitted to isolate the final second of fear and ignore the chain of decisions that led there. Officer positioning, escalation, missed opportunities to disengage, all of it now matters. Look, not to presume guilt, but to ensure that constitutional reasonableness is evaluated honestly and in full context. But Barnes also stopped short of something many advocates and critics alike were urging. It did not abolish qualified immunity. Instead, the court chose a middle path, preserving the doctrine while narrowing one of its most expansive shields. And that choice raises an important next question. Why did the court draw the line where it did? You see, in the Barnes versus Felix case, there were a number of folks who filed amicus curiae briefs. Those are friends of the court briefs. They're not parties to the case, but the Supreme Court likes to receive briefs from interested persons, okay, who may have something to offer. And there were plenty that were asking the court to get rid of qualified immunity altogether. Now, in the next episode, and the court didn't, but they took this middle path, okay, and emphasized the totality of the circumstances. So in this next episode, we're going to take a closer look at Barnes versus Felix itself, not just the holding, but the reasoning behind it. We're going to examine why the court rejected the moment of threat rule, why it declined to overturn qualified immunity outright, and how this recalibration changes the legal landscape for police shooting cases moving forward, like in this case involving Renee Good. Because understanding why the court chose a middle path is just as important as understanding what it decided. That conversation is going to continue in the next episode, episode 5. And as always, ladies and gentlemen, here on the Teske Brief, we'll let the law, not the talking points, do the talking.